Many states are confronted with emergencies, some of which threaten their very existence. Since Confederation, Canada has survived two world wars, the October Crisis of 1970, and more recently the OKA crisis. Emergencies often require a government to rely on measures which alter the normal constitutional allocation of power within the state. They may also require that states temporarily infringe or deny individual rights and freedoms. State parties to the International Covenant on Civil and Political Rights, like Canada, acknowledge this necessity in the derogation clause of the ICCPR, Article 4.3. Yet, the ICCPR places limits on the manner in which states may infringe or deny rights and freedoms. States may use emergency measures derogating from rights guaranteed within the ICCPR only to the extent strictly required by the exigencies of the situation. Further, the ICCPR treats certain rights as non-derogable rights in any emergency. This thesis focuses on the relationship between the Emergencies Act, Canada's new federal emergency regime, and Canada's international obligations under Article 4 of the ICCPR. In particular, the recognition and protection of non-derogable rights. On the international level, the legal framework within Article 4 states of emergency have been the subject of discussion and study by a variety of international organizations and legal scholars for a number of years. A consensus thus exists among states whose legal traditions are rooted in the rule of law. About certain basic principles relating to states of emergency. First, states of emergency are, by definition, temporary. Second, states employ emergency measures which are proportional to the emergency to permit a return to normalcy. Third, it seems that the likelihood of restoring peace and stability after an emergency is linked to the manner and extent to which a state respects human rights during the emergency. Finally, the potential for ensuring greater respect for individual rights in states of emergencies lie in maximizing the role of democratically elected legislative body and the role of the judiciary within the legal regime. A historical review of Canada's use of emergency legislation reflects a growing realization of this relationship. This thesis will draw on these basic principles in examining the law on states of emergency in Canada. Canada's emergency regime derives from a number of sources including constitutional provisions, the common law, statute law, and Crown prerogative powers. Until July 1988, the federal statutory regime consisted of the War Measures Act, the National Defense Act, the Criminal Code, and such ad hoc legislation as Parliament found necessary to meet a particular emergency. Of these, the most significant was the War Measures Act, founded on Parliament's exercise of its residual power in Section 91 of the Constitution Act 1867, to legislate for the peace, order, and good government of Canada, with respect to all matters not coming within the classes of subjects, assigned exclusively to the legislatures of the provinces. The War Measures Act 1914 was a blunt instrument conferring broad powers upon the federal executive during real or apprehended emergencies, whether war, invasion, or insurrection. A declaration of the governor in council that an emergency existed was conclusive evidence of the fact that all powers deemed necessary and advisable to deal with the emergency were delegated to the governor in council. Under the War Measures Act 1914, parliamentary supervision was non-existent and judicial review extremely limited. Individual rights and liberties, other than a right to compensation for property expropriated, were not explicitly protected. The limitations it imposed on executive action were few, whether in duration or geographic application. The most egregious example of the executive's exercise of emergency powers under the Act were the orders in council which led to the deportation of persons of Japanese origin at the end of World War II. In contrast, the ad hoc legislation enacted during the Korean War, the Emergency Powers Act, placed greater limits on the powers granted the governor in council. With the enactment of the Canadian Bill of Rights in 1960, Section 6.5 of the War Measures Act was amended such that the exercise of emergency powers pursuant to the Act could not be characterized as an abrogation, abridgment, or infringement of any right or freedom recognized by the Canadian Bill of Rights. while other amendments included the requirement that a declaration of emergency be laid before Parliament and the recognition of Parliament's power to revoke the Governor-in-Council's declaration of emergency, the use of the War Measures Act during the 1970 October crisis and the detentions without charge of numerous persons pursuant to that act brought its lack of protections for fundamental human rights to Canadians. Attention. It became apparent that a new legal regime for states of emergency in Canada was needed. In 1984, Brian Mulroney's Progressive Conservative Party made reform to the Canadian emergency regime a part of its election platform. In 1987, the Conservative government, in its review with the Canadian Defence Policy, issued a white paper, Challenge and Commitment, a Defence Policy for Canada, which reiterated the need for comprehensive emergency legislation capable of dealing with a variety of emergency situations. The desire to accord individual rights a greater degree of protection in emergencies also figured prominently in the government's justification for the new legislation. In June 26, 1987, the government introduced Bill C-77, an act to authorize the taking of special temporary measures to ensure safety and security during national emergencies and to amend other acts in consequence thereof. Into the House of Commons for first reading. On July 21st, 1988, Canada's new emergency legislation, the Emergencies Act, received royal assent and entered into force. The new Emergencies Act sets out 4 new categories of emergency and has created new mechanisms of judicial and parliamentary supervision. In its preamble, it sets out the following as being the fundamental obligations of government in emergencies: the safety and security of the individual, the protection of the values of the body politic, and the preservation of the sovereignty, security, and territorial integrity of the state. However, it does not expressly incorporate the provisions of Article 4.2 of the ICCPR or contain a clause setting out specific non-derogable rights. Whereas the War Measures Act had operated notwithstanding the Bill of Rights, the Emergency Act directly acknowledges in its preamble that executive action should take place within the quasi-constitutional requirements of the Bill of Rights and the constitutional guarantees of the Charter. Parliament also signaled its intention not to rely on the derogation or override clauses in the Charter, Section 33, and the Bill of Rights, Section 2, for states of emergency coming within the Emergencies Act, albeit in the preamble. The preamble also refers specifically to the ICCPR and states that the Governor-in-Council must have regard to the provisions of the International Covenant on Civil and Political Rights in its exercise of emergency powers. The nature of this obligation will be considered in more detail below. To date, the Emergencies Act has been the subject of limited public discussion, which is surprising in light of the controversy surrounding the War Measures Act. This thesis is an attempt to explore the parameters of what will likely be a continuing discussion of emergency legislation in Canada. The thesis begins by briefly examining the constitutional foundations for and the framework and legislative history of the Emergencies Act. It then considers the role of Parliament and the judiciary in this new emergency regime before focusing on the protection of non-derogable rights in Canada under the Emergencies Act. The failure of the Emergencies Act to expressly incorporate the provisions of Article 4.2 of the ICCPR or a clause setting out specific non-derogable rights will be considered in relation to Section 1 and 33, the limitation and derogation provisions within the Charter. The possible reliance by Parliament on a Section 33 override in times of emergency to deny Charter rights is a serious concern. By using Section 33, Parliament could permit the derogation of rights guaranteed within the ICCPR contrary to Canada's obligations under Article 4.2. While the Emergencies Act itself does not contain an S-33 override, the National Association of Japanese Canadians, in its submission to the Legislative Committee on Bill C-77 and the Senate Committee of The whole, on June 21st, 1988, raised the concern that Parliament may delegate the Section 33 override power to Cabinet in war emergencies. In war emergencies, the Governor and Council is delegated the broad power to make such orders or regulations as the Governor and Council believes on reasonable grounds are necessary or advisable for dealing with the emergency. Whether or not Parliament's power to override charter rights within Section 2 and 7 to 15 could be delegated in this manner will be considered in Chapter 5. This thesis proposes several arguments to address the NAJC's concern. Under Article 4 of the ICCPR, rights guaranteed therein may be derogated from or denied in times of public emergency. The ICCPR also contains provisions which set out specific purposes, including safeguarding and protecting national security and public order, for which rights may be limited. Similarly, Section 1 of the Charter permits measures which have a basis in law to limit rights in peacetime. Section 33 could operate to derogate from rights in emergencies, but subject to arguments about the delegation of the override, Parliament did not incorporate a Section 33 override into the Emergencies Act. Thus, no derogation clause applies to emergencies falling within that legislative scheme, and in such circumstances, Canadian courts will have to interpret and apply Section 1 of the Charter, the Peacetime Limitation Clause. Absent the direct implementation of Article 4.2 of the ICCPR in the Emergencies Act, or an explicit statement in the Emergencies Act designating certain rights as non-derogable, if non-derogable rights are to be recognized and protected in Canada, this must be achieved through the court's interpretation of Section 1. The manner in which the courts might achieve this end will be considered in Chapter 6. To enter into these discussions, I must make several significant assumptions. Madame Cousteau has stated that a fundamental principle which should govern emergency regimes is that emergency legislation predates the occurrence of the crises. I must assume that in national emergencies, Parliament and the executive government will look to existing legislative and constitutional authority for available emergency powers. I assume further that the Emergencies Act will not be amended and that ad hoc legislation incorporating a Section 33 override will not be created to deal with emergencies otherwise falling within the scope of the Emergencies Act. Thus, should the Governor and Council proclaim a state of emergency, the Emergencies Act will, in its current form, govern emergencies to which it applies. Without such assumptions, any serious consideration of the use of executive powers in times of emergency is difficult, if not impossible. So this is the Emergencies Act. I will put a link to it in the description, and if you'd like to continue reading, please do so, and leave some comments below. Have a great week.